1970s, when I was in medical school, we weren't just encouraged to be skeptical. It was a demand put upon us by our professors. We better be skeptical. Today, skepticism is not allowed. There's a narrative that's been out there, and whatever that mainstream narrative is, that's what you abide by. Hello. Welcome back to the Dr. Scott Jensen podcast. Once again, I want to start out with the words of George Orwell. In a time of universal deceit, telling the truth becomes a revolutionary act. That's in large part why I wrote the book, We've Been Played. You can get that at drscottjensenbook.com. Today I've got a special guest, an attorney, James Dickey, who's one of the lead attorneys at the Upper Midwest Law Center. I'm going to let him do his own introduction. But people have asked me along the way, Scott, how can you sustain the fight? This has taken a toll on you. It has to. 18 allegations against you, 6 different investigations, spending more time corresponding with the Board of Medical Practice over the last 3.5 years than perhaps any other entity in my life. So, for that reason, we're going to give you an update today. And I feel most comfortable having James do a lot of the talking about where the lawsuits are at. To briefly summarize, we've got 2 suits. One in the state district court asking the Attorney General's office, Keith Ellison, to fully comply with the Minnesota Data Practices Act. And 2, in the federal district court, we have brought action against the Minnesota Board of Medical Practice for infringing on my First Amendment rights. Having said that, I'm going to ask James if he would introduce himself, as well as perhaps comment on the fact that we live in a time where truly saying something that's true can be a revolutionary act. James, thanks for being here.
Well, thanks a lot, Scott. It's a pleasure to be here. Appreciate the invitation. And I'm James Dickey. I'm the senior counsel at the Upper Midwest Law Center. We are Minnesota's nonprofit public interest law firm that we fight for liberty and the rule of law. You can find out more about us at umlc.org. To answer your question, what does it mean to stand up for what's true in an age of deceit, and whether that's the Revolutionary Act? I think it is. I think that no matter where you're at, if you speak the truth against those who are in authority in this day and age, you are going to be the target. You're going to have a target on your back, and that's exactly what happened to you. And that's why we think at UMLC that Dr. Jensen's lawsuit is such an important one for everyone's First Amendment rights, for all physicians to be able to speak the truth, not their truth, about what is going on in medical practice and as it relates to government action.
And let me just say it again. Without James Dickey at the Upper Midwest Law Center and my private attorney, Greg Joseph, I do not think I could have sustained this fight like I have. But it's also in large part because of so many of you folks who nearly a year ago said, we're going to stand side by side with you, Dr. Jensen. And when we utilized a crowdfunding mechanism asking for dollars to help pay for the costs of proceeding with 2 different lawsuits, we went through the Give, Send, Go initiative. And you folks were incredibly generous. And so we fight on. To get James the opportunity to give an update on both of the cases, I'm going to do something a little different. I want to start with a case that isn't mine. I want to start with a case regarding a woman named Tina Gady. And the reason I want to do that is I want you to get an appreciation for the depth and breadth of what's going on in Minnesota, in America. This isn't about a family doctor in Watertown, Minnesota, having his rights infringed upon. This is about literally everyday people across so many swaths of life, whether you are a hairstylist, a nurse with a public nursing practice, a restaurant owner, a pub owner, whether you're a dentist or a doctor, whether you own a small business, whether you're a laborer and your place of employment is subject to licensure or registration or inspections or approvals. It affects all of you. But the Tina Gady case is interesting because in this situation, the question came up, When Tina Gady asked for an exemption from the vaccine, isn't it astounding that her personal or philosophical views, as she had articulated them along the way, were allowed to outweigh her actual religious beliefs in her attempt to get an exemption? James, would you start us off by commenting on the Tina Gady case, because I know that you're very familiar with it, and to me it seems sort of shocking that at the end of the day, Tina Gady's case almost seems like, as I wrote a couple notes to myself, this seems like saying that the most direct path to getting a religious exemption is to purge your brain of any analysis or reasonable consideration. You almost have to behave like Schultz, the guard on Hogan's Heroes, where he says, I see nothing, I do nothing, I know nothing. Because if you do know something, in this situation with Tina Gady, her knowing something was allowed to trump her deeply held religious beliefs and thereby deny her an exemption. James.
Yeah, so Tina Gady was fired by AstraZeneca Pharmaceuticals, which was her employer, because she refused to get the COVID-19 vaccine. And as she had asked for an exemption, like you said, from that vaccine, and they simply said, no, we're not going to give you that exemption. And the reasoning essentially comes down to, well, we think that you actually believe that the vaccine is dangerous, and therefore that's your real reason for objecting. Never mind that she amply supported her religious beliefs with significant support that she found in her own research and in her own review of religious text and what the Catholic Church in the local archdiocese were telling people about having a conscience-based objection to a vaccine. And to add insult to injury, not only was she fired from her job, but she was also told by the state that she's not eligible for unemployment benefits. So they really added insult to injury on top of that. And they did the same thing. The unemployment law judge, what they do in an unemployment hearing is they bring you in front of the unemployment law judge and they grill you for 45 minutes or so, or an hour, about why you were terminated from your job. Well, in this case, the law judge was basically going through and finding reasons why she shouldn't have gotten benefits in the first place, finding reasons why her real reason for objecting to the COVID-19 vaccine was something personal or philosophical. And then the judge denied her benefits. And now we're going, and we've asked the U.S. Supreme Court to review this case after we've exhausted our remedies in Minnesota state courts. And I'll tell you also is that we just heard last week that the U.S. Supreme Court has issued what's called a call for response. It's pretty rare that they do this. The chances of the U.S. Supreme Court taking a case are about 1%, even less, for any case, because there's just so many. And when they call for a response from the government, which they've done here, the chances jump up significantly. So we think that there's at least one justice on the U.S. Supreme Court, and maybe more than one, who are really interested in this. And we think there's a chance that this case may be taken.
So to summarize, we have a woman who says that she would like an exemption, and she articulates her religious beliefs that would warrant such an exemption. But because she has utilized her own abilities to analyze and scrutinize, because she might have somewhere along the line let it out that she actually is thinking about it as well, that analysis and her conviction that the vaccine might be dangerous in the courts so far have been enough to say, well, then we're not going to give you a religious conviction.
Right.
Or a religious exemption. We're not going to give you a religious exemption because you clearly think about things and you think this is dangerous. And it's almost like she's being pummeled because she thinks the vaccine is dangerous.
Right. And you're right. If you were to say, I know nothing, I see nothing, I hear nothing, except for this is my religious belief, and you didn't introduce any evidence of what you thought about this or any other medications in the past you've taken or anything like that, then there would be no basis to say that you don't have a religious basis for your objection. But in fact, because Tina Gady did some research and understood, as she believes, understood what the vaccine does and how it operates, and had concerns about its fast-paced approval, that led to the court saying, well, this is your real reason for not taking it. And that's really problematic.
So if we step back and try to take a 30,000-foot view of what's going on, the 5,000-foot view will be you giving an update on my two cases, James. But if we look at that 30,000-foot view, as a person who served one term in the Senate and had a chance to, if you will, participate and feel what goes on in the legislative arena, it's really sobering to me to think that our system of three branches of government, legislative, executive, and judicial, has become almost dismantled in terms of how it was intended to work, such that the legislative branch is oftentimes entering into areas where there is no expertise on the part of the legislative branch to participate, but that doesn't stop them. We have the executive branch frequently utilizing perhaps the force of its office beyond what it should and classifying it as, quote, an emergency executive authority. But I am struck by the fact that I'm sitting here with you, James, and I would never have guessed 4 years ago that I would be hiring lawyers and suing the Minnesota Board of Medical Practice or suing the Attorney General. And the reason I'm here and the reason Tina Gady is working with you and so many other physicians, but not just physicians, people from every walk of life. The reason we're here is because we literally have had to go to the courts. We've had to go to the judiciary branch of our state and federal governments for, if you will, fairness and justice, because we're not getting it through the legislative and the executive arenas. And to me, that is just so darned sobering. It makes me sad that this is where America and where Minnesota has gone.
Yeah, it's true. And, this is something that was foreseen by our founding fathers as a potential problem. Madison actually is the author of Federalist 48, and he wrote about the problem of using essentially just individual rights as this last gasp effort to restrain the government, and called them, kind of, in a way, parchment barriers, that they're only as good as the paper they're written on. Then former Justice Antonin Scalia, in a talk in front of the U.S. Senate a few years back before he passed away, brought this out and said, the real strength of our Constitution is not the Bill of Rights, which is so important, and we don't want to denigrate that. But the strength of the Constitution is in the fact that it restrains the federal legislative and executive branches. And in all our state constitution does the same thing. It's modeled the same way. So the way it's supposed to work is that the branches are supposed to stay within their powers that they have under our Constitution. But we see that because they keep spilling over beyond those powers, whether it's the incorrect declaration of an emergency, whether it's going beyond the jurisdiction to squelch your speech, whether it's denying unemployment benefits to Tina Gady because they have their own subjective views of what her reasons for doing what she did are. Those are all examples where if the legislative and executive branches were staying within where they should be under the law, under the Constitution, we wouldn't have these kinds of problems. But the fact is we are having them because they're not staying within their bounds.
Sobering reminder of what Supreme Court Justice Alito said when he made some comment to the effect that the COVID pandemic presented a stress test of mighty proportions to the Constitution of the United States.
Yeah, that's right.
James, with no further ado, I'm going to ask you to go ahead and, as much as you feel comfortable with, sharing an update regarding the two court cases, and also if you have any particular poignant comments or statements in previous cases that you think really come to bear on our cases, please share those. The floor is yours.
Yeah, thank you so much again. And just to give this update, I think that first of all, let's talk about the state court case against Attorney General Ellison. One thing that I can say after we made data requests not just to the Attorney General's office, but also to the Board of Medical Practice. And having reviewed the data that we got, there's a lot of data that we have been able to obtain by really, I think, holding their feet to the fire and demonstrating the seriousness with which we hold the Data Practices Act, the Minnesota's FOIA law.
Why did we have to hold their feet to the fire?
Well, but first, we didn't get, at least from the Attorney General's office, we got a statement saying we're withholding all this different data on various bases that, from the looks of things, were not clear at all to us.
So does state statute provide the Attorney General that kind of authority where he can decline participating in following a law?
No, of course not. And so the idea is here is, of course, the AG would say, oh, no, we've done everything we should do under the law. But we think that they've stretched the law a little bit too far in terms of what the responsibilities of the office are, and that they've withheld data that they shouldn't have withheld.
So by your willingness and the Upper Midwest Law Center's willingness to hold their feet to the fire, have you seen any results up to this point? Have you gotten more information than you were originally given in regards to my case? How has that played out thus far?
Yeah, so one of the things that we have gotten is there was some data that the Attorney General's office actually released after we noted that we had in fact requested this data to be public, which is the trigger point for it to be made public. And that's only a few documents, to be fair to them. But one thing we've also gotten from them throughout this is a real understanding of what kind of data they had and what kind of participation the Attorney General's office had in the investigation related to you, and the Board of Medical Practice's investigation as well. And I can't say too much more on that front right now, but I would say that just having brought these cases, the data case, and obtaining some of the information that we sought, and significant more information about the nature of the back and forth between the AG's office and the Board of Medical Practice, I think it's been really enlightening, and it's actually helped quite a bit with understanding the claims that we are bringing in the federal case against the Board of Medical Practice, and the timing of the actions the Board of Medical Practice took.
I've been asked, well, why are you even bringing the Attorney General into the equation? And what I've said is basically the Minnesota Board of Medical Practice is where I have my beef. I feel like my First Amendment rights were infringed upon. But the Minnesota Board of Medical Practice, they have to have an attorney in this process as well. Well, their attorney is the Attorney General's office. So arguably, Keith Ellison is the head of the legal team representing the Minnesota Board of Medical Practice in my suit against them. So understanding that fact perhaps provides an understanding as to why you and Greg Joseph would say we need to submit a Data Practices Act request, which is like the federal FOIA request. Mm-hmm. We need to do that, and we need to put it to both the Minnesota Board of Medical Practice and the Attorney General's office, because there would be back and forth. So we've done that.
Right.
And initially, the Attorney General's office said, we'll release some things, but we're not going to play ball to the extent that you might want us to.
Right.
And by holding their feet to the fire, they have turned over some additional documents and also shared some other perspectives that we might not have received otherwise.
Right.
Having said that, is there anything that has come to light regarding how the Attorney General's office participates in keeping records or holding on to documents? Mm-hmm. Is there anything there that you could comment on?
Yeah, there's one issue that I think is perhaps the most troubling issue that remains in the Data Practices case in state court, which is that the Attorney General's office has been, and I think almost every single state agency in Minnesota does this. They use Microsoft Teams, which is basically like a chat function, an inter-work office chat function. And I think studies have shown and reports have shown that Microsoft Teams and Slack and other like channels have really replaced email quite a bit over the last maybe 5 to 10 years, especially since COVID, in terms of how these offices communicate internally and with one another. And so the Attorney General has a policy that I think they delete all Teams data after 30 days. So if you were going to make a data request, a FOIA request to the Minnesota Attorney General's office and ask for all data related to Scott Jensen, you would only get the Teams data. So they could have had all kinds of conversations more than 30 days in the past. You'd only get the Teams data for 30 days if it exists. And then in addition to that, if you think about that from the timing of this lawsuit, you originally sent a tweet out in January of 2023. And we made a data request on April 20th, 2023. So that any Teams data related to the timing or at the time that you made a statement about the Attorney General's office would be lost and has been lost based on this retention policy that we think really undermines the purpose of the Data Practices Act.
So what you're saying is if I was in my own medical office, if I was texting back and forth with different department heads and things like that, and having conversations perhaps about an employee's performance or perhaps an HR issue arose, do I have the option in that situation where I get to erase everything after 30 days so that that employee or whatever the situation is, those people can't get at that or not?
Well, it depends. I mean, the government has different rules applied to it. So your private practice is always going to be subject to a different set of rules, generally speaking. You can...
So it might well be that corporate America or small business America wouldn't have the same ability to wipe out everything but the last 30 days and get away with it.
It's possible. It could be the other way around too, which is that the government is actually, because the government is for the people and by the people, it has an obligation to maintain records under the Data Practices Act and the Minnesota Official Records Act to make sure that we, the people, know what's going on. And so, when you see a retention policy like this, and other state agencies, by the way, we're aware of, have even shorter retention policies. When you see this kind of thing, you say, hold on a second. They're deleting their chats about people like Scott Jensen, potentially, after 30 days, when that kind of stuff would be relevant if there were a lawsuit to come about. I mean, that kind of thing is really troubling to me, and it shouldn't be happening.
Okay, so we're going to turn to an update on my case. My case really is a First Amendment case. And just a brief refresher on the First Amendment. As a non-attorney, I would say that 5 things jump out about the First Amendment. One is free speech. One is religion. One is the press. One is the right to assemble. And one is the right to petition. Those 5 things are captured by the First Amendment. There's other amendments, and I believe the 14th Amendment might be one, that guarantees due process. So I've spilled an awful lot of what I know about the Constitution from an attorney's perspective. Can you take it from there, James, and give us first an update on our state case against the Attorney General in regards to where do we go next?
Yeah.
It sounds to me like what you've shared and the fact that the Attorney General's office has already relinquished documents that they weren't going to. At some level, that's a win already. We said, you can't do this. They've said they can, but then they gave us more information. Perhaps there's more information coming, and perhaps there's a question to be raised regarding a 30-day expiration on Teams internal texting. And then the second case would be, where are we at with the Minnesota Board of Medical Practice and the federal courts?
Yeah, so first, I think that one of the reasons why we made data requests both to the Attorney General's office and the Board of Medical Practice is because we know that a lot of the data is going to overlap. We want to make sure we catch all the relevant data. And I think we've gotten, especially from the Board of Medical Practice, a lot of relevant data. And so I think, at some point you do ask the question like, well, is there really any, we always want to look and say, is there value in pushing forward on this particular issue, or is it better to spend our time and effort elsewhere? And I think with the state data case, that we're probably going to make some kind of a compromise at this point to go forward so that we don't have unnecessary claims hanging out there when we feel like we've gotten all the information that we were really seeking.
From a layperson's perspective, one other thing that I thought happened during this process on the state court case with the Attorney General is just by your requesting the court and specifically the judge to get involved, the judge and his or her staff have gotten involved in terms of taking a look at some of these documents.
Right.
And that process in and of itself, I think, shook a few apples loose from the tree so that they would fall to the ground and come into our collection. I think having a judge tell the Attorney General's office, you don't get to unilaterally declare what you're not going to share, did have impact. Is that valid?
Well, I think that the judge, in this case, Judge Kane in Carver County, really took a really aggressive approach of trying to get the parties to work out what we really were, what our their defenses really were, and also from our side, what do you really want out of this data request? And I think that was really helpful. We narrowed down the issues a lot. I do give credit to the lawyer for the Attorney General's office working on the case opposite us, who was willing to actually work with us to help us understand why they were protecting certain data and why it was not going to be public in their point of view, which from a lawyer's perspective on my side, I say, well, that's great. I need to know that kind of information to make an honest determination. So the judge, I think, has done a terrific job already, even though she hasn't made any decisions or anything like that, because her proactivity has made the process so much more smooth, I think, and it has clarified what exactly the Attorney General has been withholding. And armed with that information, it allows us to make a more intelligent appraisal. What exactly do we want to do with this data going forward? And I think we're in a place right now where we have gotten a lot of what we wanted to. And so while we're not going to say anything right here today as to what the next step is concretely, we feel like we've gotten a lot of what we were looking for in the lawsuit, and we should be spending most of our time on the next one I want to talk about with you, which, as you mentioned, the federal lawsuit against the Board of Medical Practice. And on that, I'll just go ahead and jump into that.
Please do.
So we argued this case, and Greg Joseph did a terrific job as lead counsel on December 1st of last year in front of Judge Jerry Blackwell. And Judge Blackwell has the case under advisement, as it's known, meaning that he's going to make a decision at some point in the near future. We're hoping that decision will come down in the next couple of weeks, maybe the next month. Sometimes it takes a little bit longer on complex issues. But I think that the case was so well argued by Greg, and I think that the arguments really put the government and the Board of Medical Practice on their heels, and they were forced to make some crucial admissions in that hearing. One of the ones that I think is so important is that the judge asks the Board of Medical Practice's attorney, well, does this statute, this law that allows you to investigate, give you kind of carte blanche to do a fishing expedition into anything that a doctor says? And the answer by the Board of Medical Practice attorney was essentially, well, yeah, because if he said it in public to the people, then who knows what he said to his patients? That was stunning to me, because there is no government right to just go fishing through all of your papers just to find something that doesn't exist. It's like, what is it, like Stalin used to say, show me the man and I'll show you the crime. I mean, that's what it sounded like to me in court. And I think my eyebrows, hopefully the judge didn't see it, but I think my eyebrows shot up when I heard that answer to the question.
Well, I remember I was sitting in court listening, and I remember feeling a certain warm glow that the judge would point that out very specifically, that literally any complaint without any due diligence or credibility,
right,
anonymously put forth, could potentially provide the Minnesota Board of Medical Practice with all that they needed to go fishing, whether or not they wanted to explore the internal workings of my office, whether or not they wanted to make a comment on the judging of whether or not my handwriting was neat.
Right.
I mean, these kinds of things literally became on the table, and the Minnesota Board of Medical Practice did, in fact, bring those things up in our face-to-face hearing in March of 2023. And so when you say that, I appreciate your sensitivity and awareness to it, James, because for me, as a non-legal person, when the judge recognizes the potential for this to provide the basis for fishing expeditions, I did feel better.
Yeah, and exactly. I mean, he clearly understood that issue as a real problem. And I want to. You talked about the First Amendment having certain protections, and you named 5 of them off. But I think that one of the ones that people don't really know about, and this is what Greg got into in the hearing, and he was able to make this point really clearly in a way that I thought was eye-catching. And the judge actually asked opposing counsel, who basically said, like, we don't want you to apply that standard. And I want to read from this is the Ninth Circuit Court of Appeals. Okay.
When?
2014. So this is pre-Trump.
Okay.
This is not a Trump judge situation.
So this is back when I used to get along with the Board of Medical
Practice.
Practice.
Right. Before anyone was scrutinizing you extra. And this is 2014. This is before President Trump ever became president. So this is the Ninth Circuit, which does not exactly have the most conservative reputation, if I may say, out there in California and Washington and Oregon, and other states too. And the Ninth Circuit says this. And as we're talking, just to give some context, we're talking about what rights does a doctor have when making statements to the public, even about medical procedures, okay? about health issues, because you hear a lot of criticism like, well, you can't just let disinformation get out there, then people are going to get confused, and the dim view that some of those people in the media and some people in government think of their citizens who their constituents, that they can't actually figure things out for themselves. So here is what the Ninth Circuit Court of Appeals said in a case called Pickup versus Brown from 2014. Thus, for example, a doctor who publicly advocates a treatment that the medical establishment considers outside the mainstream or even dangerous is entitled to robust protection under the First Amendment, just as any person is, even though the state has the power to regulate medicine. And the court summarizes this approach after this lengthy paragraph, citing a number of different law review articles and cases, and says, thus, outside the doctor-patient relationship, doctors are constitutionally equivalent to soapbox orators and pamphleteers, and their speech receives robust protection under the First Amendment. And that is exactly the basis on which the Board of Medical Practice was investigating Dr. Jensen, because he was making statements on his view about the government response to COVID-19, and his view about medical procedures and treatments that are out in the public eye and being considered by the public. That's the reason that they investigate it. And our view is very simple, and I think it was made very forcefully in our papers and our arguments, that if Dr. Jensen has an absolute right, speaking to the public outside of the doctor-patient relationship, to talk about these kinds of issues that are matters of public concern, which occupy the highest rung of First Amendment protections. And the Board of Medical Practice does not have any jurisdiction to investigate someone based purely on public statements about matters of public concern. It's really simple. And what they did in this case is you had 5 investigations, at least 5 discrete investigations, 18 total if you count up all the different complaints. And some of which, by the way, are based on things like a DFL press release. Okay, I mean, we're talking about really, really weak arguments. And in response to those complaints, instead of just saying, "Hey, we're done here. This is public speech, right? This is First Amendment protected speech," the Board of Medical Practice says, "Yeah, no, we should investigate this, and let's make Dr. Jensen respond to it. And oh, by the way, let's write in our demand for his response that, in fact, if you don't respond to us because you believe your First Amendment rights are violated, then we might consider some further action against you for that." So this is a pretty straightforward issue. I mean, I think that the judge really understood it at the hearing.
You might be wondering, as a viewing audience, is there a real application here? And I can give you one right now without going into any specifics, because I'm not really interested in having any more correspondence come from the Board of Medical Practice in the near future. Right now, there is a tremendous energy in the press and in the world of healthcare regarding medication-assisted weight loss. And we're seeing products that originally that indicated for treatment of, per se, diabetes, now being used in some situations off-label, and in some situations we're seeing pharmaceutical companies go back to the FDA for specific indications. But I have been asked when I have given public addresses about my thoughts on this, and I have veered away from commenting on it because I do not want someone to say, well, Dr. Jensen recommended this or that, because I'm not their doctor. I've gotten in the habit, James, of telling the audience I'm addressing, anything I say here should not be interpreted as medical advice. None of you are being addressed as patients of mine. Even if some of you in the audience has seen me or not, you are not my patients in regards to my comments here. I'm speaking as just an ordinary American citizen with First Amendment rights. But you can see where this has a chilling effect on doctors' willingness to comment on these things. We have many issues that we could be talking about today in the public press, in the public square. Is testosterone all good, or is there danger to it? Does it have an impact on prostate cancer risk? Do statin drugs have only positives, or what are the negatives? Where are we at with anti-obesity drugs? What should we be doing about certain surgeries that might take care of internal conflicts? There are so many things. And if the public is denied that kind of frank conversation, how is, number one, the First Amendment being held up, and two, how is this of value to a country that cherishes a tradition of free speech, open discussion, and that the public square is a place where it gets robust.
Right.
And we don't all agree, but we continue to debate the issues.
Absolutely. I mean, the idea that you can't talk about the complications related to those different issues, the dispute over some of those issues freely in public is absurd. I mean, we have a federal drug administration that exists to publicly decide issues related to whether or not certain drugs are going to be allowed or not allowed, and that's all in the public sphere, right? You've got, people go before Congress to talk about issues related to state responses to COVID-19, federal government responses to COVID-19. These things are all in the public. We have a right as Americans, and I think that it protects us, our health, to have that right, to have that robust discussion in the public. And the First Amendment is exactly what is designed to allow that to happen.
And bringing it right back to everyday people, every year, new doctors are coming out of medical school and their residencies. In the late 1970s, when I was in medical school, we weren't just encouraged to be skeptical. It was a demand put upon us by our professors. We better be skeptical. Today, skepticism, particularly as it relates to trying to provide context for whatever the issue that we're addressing centers around, skepticism is not allowed. There's a narrative that's been out there, and whatever that mainstream narrative is, that's what you abide by. And I want to close with this one last comment regarding the Minnesota Board of Medical Practice. During my trials and tribulations with the Minnesota Board of Medical Practice, I reached out at one point in time to ask the board what the standard of care was in regards to off-label use of a specific medication. And the board came back and told me that they don't participate in the determination of what the standard of care is that I would be held to. But they also said, but if you do this and we get a complaint, we'll investigate you. If you don't think that has a chilling effect on me, you must have your head in the sand. James Dickey has been kind enough to provide us with a professional opinion and update as to where we're at. We talked about other cases than just mine, and I think we need to. At the end of the day, like never before in my lifetime, we're leaning into the courts to help bring about some level of measured fairness and, if you will, Constitution being upheld. I want to say thank you on behalf of James Dickey and Dr. Scott Jensen for listening in. You need to engage because remember, when telling the truth has the potential to be perceived as a revolutionary act, something terribly wrong has happened. Dr. Scott Jensen, please follow us on Facebook, Instagram, YouTube, TikTok even, and watch us. Thank you.